New Mexico Real Estate Basics. Page 25. What are an agent's duties and obligations? Once an agency relationship is created, the broker owes certain fiduciary duties to a client in addition to the basic duties previously listed. Generally, fiduciary duties require the placement of the client's interests ahead of the interests of any other party to the transaction. Additionally, the New Mexico agent must also disclose to the client all information known by the broker that is material to the transaction and that is not known to the client or could not be discovered by the client through a reasonably diligent inspection. The agent must also disclose any financial interest the brokerage has in the transaction. Finally, the New Mexico broker may not accept any fees from anyone other than a client or, with the principal's consent, the other party to the transaction. In New Mexico, the agent is obligated to place the client's interest ahead of the interest of any other party, loyalty, unless to do so violates the law. The agent must fulfill the instructions, obedience, within the scope of the agency agreement, unless they are unlawful instructions. When a seller's agent uses superior skills to help the seller arrive at a realistic listing price, develop a marketing plan, and negotiate offers, reasonable care is demonstrated. A buyer's agent demonstrates reasonable care by helping the buyer evaluate property values, financial alternatives, offers, and counteroffers. The duty of accounting requires the recording and reporting of all funds received from or on behalf of the principal. State law requires that these funds be deposited into the broker's trust account immediately after the date on the document identifying receipt of the last signature of acceptance. Obviously, as mentioned earlier, unlawful commingling is illegal. C2.C.8. Conversion is the illegal practice of spending commingled funds for personal use. Brokerage relationship disclosures. What are broker duties disclosures? When working with consumers in a real estate transaction, New Mexico law requires that brokers provide written broker duties disclosures. The written disclosure form, signed by the client, verifies that the broker has, in fact, discussed broker duties with the client. The disclosure must include a list of the broker duties and any conflicts of interest. And additionally, a broker must disclose any written brokerage relationship with another party to the transaction. The broker duties include honesty, reasonable skill, care, diligence, assistance throughout the transaction, unless written instructions to the contrary are given, and disclosure of adverse material facts actually known. A complete list of these duties can be found in 16 NMAC 61.19. At what time must the disclosure be made? The initial disclosure must be in writing and made prior to the time a broker generates or presents any document with the potential to become an express written agreement, contract.